inception of the League of Nations after World War I, Indigenous peoples have continually brought their concerns to international fora. In 1924, Ratana and a delegation of Māori travelled to London to protest New Zealand's breach of the Treaty of Waitangi and petition King George for redress. Redress was denied. In 1925, Ratana also journeyed to Geneva to address the League of Nations, but he was turned away. Other Indigenous peoples sought an audience with the League of Nations as nations, but they too were turned away. Since that time, Māori have joined with other Indigenous peoples to participate in the development of international law and inform the international community of the issues and concerns of Indigenous peoples. Currently, the United Nations looks like this. This diagram is a simplified version of the United Nations and focuses on those parts of the UN that deal specifically with Indigenous peoples' human rights. The Declaration on the Rights of Indigenous Peoples, having been adopted by the General Assembly, now joins other international declarations as part of international law. The newly formed expert mechanism on the rights of Indigenous peoples will advise its parent body, the Human Rights Council, on the rights of Indigenous peoples. The Permanent Forum on Indigenous Issues is an advisory body to the Economic and Social Council. The Permanent Forum's mandate is to advise on Indigenous issues related to economic and social development, culture, the environment, education, health and human rights. The special rapporteurs are experts appointed by the United Nations. They write reports based on country visits and research. Their reports are presented to the Human Rights Council. The Secretariat is the administrative arm of the UN and ensures that meetings are organised and reports completed. The Secretariat is also responsible for administrating the voluntary funds for travel grants and small projects that we will discuss in more detail later.
I consider this kind of fighting as something that it's not tangible. So what you are achieving here is not something that you can hold in your hands. But the most important point here is to achieve justice, social justice, not only for Indigenous people, because doing social justice for Indigenous people is doing social justice for the entire world, because the problem of Indigenous people is the problem of the world. So what I really aspire or consider to achieve in the future is an equal system for everybody.
The UN Declaration on the Rights of Indigenous Peoples is the culmination of over 20 years of work. The Declaration was drafted in the Working Group on Indigenous Populations in the 1980s. It then passed to the Subcommission on the Protection and Promotion of Human Rights, which adopted it. It then moved to the Human Rights Council, who created a working group with a mandate to elaborate the Declaration. The Declaration remained in this working group for many years and was eventually accepted with amendments. It was then returned to the Human Rights Council, who passed it on to the General Assembly, who finally adopted it on 13 September 2007. New Zealand was only one of 4 states to reject the adoption of the Declaration at the General Assembly. Of the other 3 states that rejected the adoption of the Declaration, 2 have since changed their position. The Rudd Government of Australia has indicated support for the Declaration, and the Canadian Parliament has endorsed the Declaration. During the drafting of the Declaration, it was agreed amongst Indigenous peoples and the UN that the Declaration set out the minimum set of acceptable rights. However, many states chose to ignore this position and insisted on changes to the text before they would accept it. Māori participated in the original drafting of the text, as well as the more recent attempts to defend the original text. Māori have consistently preferred the original text, but have realised that the overwhelming majority of Indigenous peoples favoured limited change and preference to no declaration. As such, Māori did not block consensus on the amended text. The Declaration on the Rights of Indigenous Peoples recognises a wide range of basic human rights and fundamental freedoms of Indigenous peoples. Among these are the right to self-determination, an inalienable collective right to the ownership, use and control of lands, territories and other natural resources, the right to develop Indigenous political, religious, cultural and educational institutions, along with the protection of cultural and intellectual property. The Declaration also highlights the requirement for free, prior and informed consent in relation to activities that impact on Indigenous peoples, their property or territories. It also establishes the requirement for fair and adequate compensation for violation of the rights recognised in the Declaration and establishes guarantees against ethnocide and genocide. The Declaration on the Rights of Indigenous Peoples is significant to Māori because it complements the collective rights of Māori enshrined in the Treaty of Waitangi. When the Declaration was a draft, it had already been referred to by the Waitangi Tribunal and the Court of Appeal. Lawyers can use it as a point of reference in legal submissions. The Declaration can be used by Māori in other ways, for example, as a tool when lobbying Treaty of Waitangi settlement negotiations. It can also be used by Māori and the judiciary, including the Waitangi Tribunal, to analyse draft legislation.
What Indigenous peoples have been able to successfully achieve within the UN system is a wake-up call that we're not extinct. We're not dying out, we're very much alive. The issues that our forefathers spoke about, we're still speaking about them now, and there's every indication that future generations are going to be saying the same thing. We have proven beyond any doubt that we take our rights seriously.
On 14 December 2007, the UN created a new body called the Expert Mechanism on the Rights of Indigenous Peoples. This body replaces the Working Group on Indigenous Populations, also known as WIDGIP. The Expert Mechanism on the Rights of Indigenous Peoples will hold its first meeting in October 2008. It is made up of 5 experts who will meet for 3 days in Geneva, in Switzerland.
Its role is to, among other things, provide the Human Rights Council with expertise and information and studies about Indigenous people's rights, what those rights mean, how they are to be implemented, and so on. It also provides a forum for Indigenous peoples to go to raise their human rights concerns.
The experts of the Expert Mechanism on the Rights of Indigenous Peoples are appointed by the President of the Human Rights Council for a period of 3 years. The experts may be of Indigenous origin. Governments and Indigenous peoples may attend the meeting of the Expert Mechanism. Both will have the status of observers. The meeting is controlled by the experts.
We think it's important that we have a voice within the United Nations because Indigenous peoples around the world are not fully represented by their governments, and it's only governments that meet at the United Nations, so it's important that people themselves, the civil society also engage itself. And here it is important that Indigenous peoples that are organized at their homelands, that they are able to to be part of the United Nations work.
The United Nations Permanent Forum on Indigenous Issues was established in 2000 by the United Nations Economic and Social Council, also known as ECOSOC.
The forum's mandate is very broad. The forum deals with environment, development, health, education, culture and human rights. And its job is to discuss these issues and to issue recommendations to the UN system on these issues so that they will change their course regarding indigenous peoples' concerns. Secondly, to raise awareness. Again, the forum is supposed to push to create huge awareness about indigenous issues. And the third is to coordinate in the intergovernmental system indigenous issues.
The Permanent Forum does not have a mandate to monitor state activities, even though this was one of the original visions of Indigenous peoples who participated in the working group that brought about the creation of the Permanent Forum. The Permanent Forum is made up of 16 experts. 8 are appointed by governments and 8 are nominated by Indigenous peoples.
There really needs to be a permanent forum on indigenous issues because we need to have a body within the UN that will bring together all the gains or lessons that we have learned from engaging with these various UN bodies. There has to be one single body where we can bring and look at all this together and see how we can use the gains achieved to be used for the indigenous people's own development and, of course, for the respect and promotion of their own rights.
The Permanent Forum is now so well attended by Indigenous peoples it has become unworkable. At the most recent meeting in 2008, it is estimated that 2,500 people were in attendance. With these numbers, it is impossible for all Indigenous peoples to speak. Not only that, but it has become clear that many international institutions are failing to take into account the Permanent Forum in their formation of policies and programs that affect Indigenous peoples. For example, the United Nations Forum on Climate Change does not attend the Permanent Forum and does not allow Indigenous peoples to participate in its meetings. The Permanent Forum will need to consider how to address these issues if it is to retain its integrity and become a viable authority on issues pertaining to Indigenous peoples. Māori have participated in the Permanent Forum, often choosing to highlight issues they are currently dealing with. For example, Ngāi Tahu, in conjunction with Treaty Tribes Coalition, addressed the Permanent Forum in 2004, highlighting the then Foreshore and Seabed Bill. Their presence and submissions to the Permanent Forum drew support from Indigenous peoples and put the government on notice that Māori were prepared to take their concerns to international fora.
I believe in the UN. I think it can achieve not only things for my own people in Australia, but also for Indigenous people worldwide. On an international basis, it's the only place to go, really, in order to pursue the recognition, protection of our human rights, but particularly the recognition and protection of those distinctive rights that we hold because we're Indigenous. And the United Nations is a proper place to pursue the recognition and protection of those rights.
United Nations Special Rapporteurs are independent experts appointed by the UN. Special Rapporteurs report on and investigate specific human rights issues. Governments do not have to follow the recommendations of the Special Rapporteurs. However, as their reports are presented to other United Nations bodies, they have the potential to encourage relevant states to address the concerns raised. The Special Rapporteur on the Situation of Human Rights and Fundamental Freedoms of Indigenous Peoples is Mr. James Anaya from the United States. He was appointed on 26 March 2008 for a term of 3 years.
The Special Rapporteur on the Situation of Human Rights and Fundamental Freedoms of Indigenous Peoples is a mandate of the Human Rights Council, the United Nations Human Rights Council. There are several of these special procedures, as they're called, and the mandate of the Special Rapporteur on Indigenous Peoples in particular is to investigate the situation of human rights of Indigenous peoples around the world, engage in dialogue with states, Indigenous peoples themselves, and other relevant actors about the problems facing Indigenous peoples, particularly when faced with violations of their human rights, and try to promote solutions to those problems through making recommendations. And so the mandate involves receiving information from Indigenous peoples, communicating with governments on the basis of that information, making country visits, sometimes up to 10, 12 days, sometimes shorter visits, with a view towards always trying to look for solutions to those problems through constructive dialogue.
The previous Special Rapporteur, Mr. Stavenhagen, visited Aotearoa in November 2005. His report made a number of recommendations, including the entrenchment of the Treaty of Waitangi, providing binding powers to the Waitangi Tribunal, and repealing or amending the Foreshore and Seabed Act. The government response to his report was appalling. Both the Prime Minister and the Deputy Prime Minister criticised the rapporteur personally, as well as criticising the body he reports to within the UN. In doing so, they did not address the issues raised by the report, which remain outstanding. Other special rapporteurs also play an important role. Madam Erica Irene Dias has written a number of reports on issues affecting Indigenous peoples' heritage, protection of cultural and intellectual property, Indigenous peoples and their relationship to land, and Indigenous peoples' permanent sovereignty over natural resources. Another special rapporteur, Miguel Alfonso Martinez, wrote a report on treaties, agreements and other constructive arrangements between Indigenous peoples and states. Often such reports are followed up with expert meetings which reiterate the findings of the report and give further recognition to the recommendations they contain. There are also other special rapporteurs that deal exclusively with a certain theme. For example, there is a special rapporteur on the right to food and another one on religious freedom. Information can be provided to these rapporteurs for consideration in their report writing. The authority of reports can be used by Indigenous peoples as leverage with their governments. Māori can use such reports in arguing for changes.
The enduring memory I have of the United Nations are the solidarity of Indigenous peoples, the warmth and generosity of Indigenous peoples. I've made very good friends, some of whom have since died. One was a Karen and got killed by his government when he returned from the UN, so some people have paid a far greater sacrifice than we have. And you feel privileged to have been part of that, to have known those people.
The International Decade of the World's Indigenous Peoples, 1995 to 2004, was proclaimed by the General Assembly. The theme for the decade was Indigenous People, Partnership in Action. A coordinator of the decade was created, and the voluntary fund for the decade to assist the funding of projects and programs which promote the goals of the International Decade was established. In 2004, the General Assembly proclaimed a second International Decade of the World's Indigenous Peoples to commence on 1 January 2005. The Under-Secretary-General for Economic and Social Affairs has been appointed as the coordinator of the second decade, and a voluntary fund has been established as a successor to the already existing voluntary fund of the first decade.
The important thing in the UN, and this has happened over the last 2 decades, is that we have created awareness around the world about Indigenous peoples who previously were Indigenous peoples or invisible populations. Nobody really gave much attention to the fact that Indigenous peoples existed in many parts of the world and had a most important relationship with the environment and the territories. And now that realisation is coming through, and the United Nations particularly has championed these causes. And so while states collectively in the United Nations recognise these things, we still have this problem of getting states individually to do something about it.
One of the concrete outcomes of both international decades has been the establishment of 2 voluntary funds. In UN speak, the voluntary fund is an account which states can donate to voluntarily. Donations can also be accepted from non-governmental organisations and individuals. The New Zealand Government's contribution is ad hoc. As the Special Rapporteur stated in his report on New Zealand, the New Zealand Government has also occasionally contributed to the United Nations Voluntary Fund for Indigenous Populations. Indigenous peoples can apply for travel grants to attend the Permanent Forum and potentially the expert mechanism on the rights of Indigenous peoples. Application forms can be found on the UN website. The deadline is 1 October of each year. For example, in order to apply for a travel grant to attend the 2009 Permanent Forum, you must apply for a travel grant by 1 October 2008. The United Nations also has a second voluntary fund available to Indigenous peoples. This fund is for projects relating to the United Nations' second international decade of the world's Indigenous peoples. Projects can receive a maximum grant of $10,000 US. Another concrete outcome of the international decade was the establishment of the Indigenous Fellowship Program. The aim of the program is to give Indigenous peoples the opportunity to gain knowledge of the United Nations system and mechanisms dealing with human rights in general and Indigenous issues in particular, so that they can assist their organisations and communities in protecting and promoting the rights of their people. In its first decade, more than 100 Indigenous men and women from 46 countries undertook the program. 2 Māori have participated in this program, myself and Catherine Davies of Aotearoa. Keeping abreast of international law as it pertains to Indigenous peoples is important. The following websites should be reviewed regularly. There are also numerous Indigenous email networks that you can join depending on the issues that you are interested in. This now concludes our program. AirTrust would like to thank all those who assisted, supported and worked on this project. We trust this resource will be of value to Māori.